More back to the issue. I
Right.
think that for me it's quite absurd. The letter by the Clerk of Parliament. We all have a duty to protect the integrity and to insulate certain institutions of state from certain remarks, comments, and probably public ridicule. In as much as you have a mandate to carry your duty, you ought to consider the circumstances prevailing. More, we are very much aware that there is a motion for stay of the execution of the judgment before the High Court, Tamale.
Okay.
It is also the case that an application for certiorari is pending at the Supreme Court.
Right.
All these applications seem to impugn or attack the judgment of the High Court, Tamale, in respect of the Kpandai by-elections. What the clerk, through this letter, has done is to give effect and to put into execution the judgment of the Kpandai High Court, which is a subject of two applications. The first application is a stay of execution pending the hearing of the application. And the second one is a certiorari application seeking to impugn the integrity of that particular judgment. So when you have these two applications pending before courts, it is always right and proper that even though the law may have mandated you to carry out an activity, you should wait for the outcomes of these applications. So for instance, the Clerk of Parliament has gone ahead to write to the Electoral Commission. The application for stay of the execution of that judgment is tomorrow at the Tamale High Court. If it so happens that the judge decides to stay the execution of that judgment, what would have happened to this letter? You would have exposed Parliament to public ridicule and probably public contempt. In the event that the judge refuses the application for stay, people will be right to say that, well, did you know the outcome before the application was even moved? Because what you have done is to overreach whatever happens in court tomorrow. If the judge decides that I won't stay, people would have the right to say that, well, he knew all along that the judge was not going to stay the application. So that is why he did that. Because whatever happens in court tomorrow, or whatever happens in court at the Supreme Court on the 16th, the motion for certiorari has been fixed for 16th December, and the stay of the execution for the judgment is tomorrow. Whatever happens tomorrow, or whatever happens on the 16th at the Supreme Court, have direct consequences on this particular letter. Because if the court decides that it is going to stay the judgment, it means that this particular letter has no effect now. Because what you have done by this letter is to put into effect and go into execution of the judgment of the court, which can be stayed. It's a probability. So I think that for us to shield our institutions from certain remarks, we should sometimes, hasten slowly. Assuming on the 16th, the application for certiorari is heard, and the entire judgment that the Clerk of Parliament seeks to put into execution is quashed. What happens? Then you expose Parliament, a huge institution like this, to public ridicule. So that is why some of us have taken the view that I met Mr. Gyakye over the weekend. He was at Wenchi to mourn with us, a good gentleman. But I believe that this is a misstep. He really did not put into consideration a lot of factors. And it is very worrying, especially for our judiciary, because these days, matters of the judiciary is all over the place. Assuming the Kpandai High Court refuses the stay tomorrow, people will be that, well, the Clerk of Parliament, he knew they were going to, that's why he went ahead to write to the EC. We don't want that.
Well, let me ask you this.
Yes.
What has always been, as a matter of principle,
Yes.
what has been your stance on this debate? Because the debate has been going on for a very long time.
Sure.
But I think that because of the kind of politics that we do, we tend to sort of shift the goalpost depending on where we find ourselves. So there are two schools of thought.
Sure.
And you are a lawyer, so the two of you are lawyers.
Yes,
You're in a better position to school me or to teach me. When a stay of execution is filed,
yes,
merely,
yes,
you file it, you go to court and say stay it.
Yes.
Does that in itself operate as a stay?
Yes, it does. Let me explain to you.
Pending the determination of the judge as to whether to stay it or not,
Yes,
does it?
yes. So let me explain
Educate
to
me on
you.
this.
A stay of execution comes in two forms.
Okay.
There is the automatic stay where 7 days after judgment or ruling, it's frozen. You cannot go into execution. Then there's one that comes by an application. So when you file an application for stay of execution pending appeal, the rule is that all proceedings relating to that particular judgment should be stayed until the final determination. And this is provided for in law. If you take CI 19, the Court of Appeal rules, I think Regulation 27.2, it states clearly, I wish I could just read it out. It states clearly that whatever happens after a court's judgment, when there's a stay pending before a higher court or the same court, all proceedings to it should be stayed until the determination. The argument being made for the clerk is that he is not a party to the suit pending at the Kpandai High Court. But what he's seeking to do is to execute the judgment. So he's taking a step in respect of a judgment which has been a subject of a stay application. Okay, so ordinarily, he being a lawyer, at least should have, per the dictates of Regulation 27.2 of CI 19, that is the Court of Appeal rules, should have reason out to know that, you know what, whatever happens in court tomorrow, that is it what 10th, right? Has direct consequences on my actions. What will I lose if I should just wait briefly to hear the outcome of this application?
Okay.
Because that is my point. Because you see, if the judgment is stayed tomorrow, what happens to his letter?
That's fine. So, and I don't want us to personalize it because he's not working in his personal capacity.
Oh, definitely, of course. I mean, he's a good gentleman,
okay.
Yes.
Would you say that per the legal arguments that you have just canvassed,
Sure.
does that mean that Parliament has erred in law?
Not necessarily, because they are also acting according to law.
Okay.
He has a mandate to inform the Electoral Commission when he deems or when the circumstances are such that there's a vacancy in Parliament. So he's performing his constitutional duty and rules.
So there's no constitutional legal breach?
There isn't.
Per the decision of Parliament to inform?
Yes, there isn't.
There's no breach?
No, there isn't. Legally,
okay.
He would argue that he's performing his mandate as the clerk of Parliament.
Okay.
And when somebody is performing his mandate, you can't fault him. But law thrives on justification.
Right.
You see, it's a concept in law that application and operation of law, most times, all the times, should find some form of justification. Okay, so you are obliged to do this particular thing per the provisions of law, but are you justified by the prevailing circumstances? We always ask ourselves, I mean, there's a concept in law that law in itself has a moral character. That is what we teach us today. Law in itself is not just law, it has a moral character. So if the offense of stealing, if you steal, you have committed an offense of stealing, you can be jailed. But morally, it is wrong to also steal. So, like incidental to legal provisions are moral consequences. So yes, he may have the right, he may be obliged by the Constitution to perform his duty, but is it justified by the prevailing circumstances in the sense that it is a possibility that the judge tomorrow, upon hearing the application for stay of execution, could stay that judgment, and the effect is that nothing can be done in respect of that judgment until the final determination of the appeal. So when the judge is able to do, or when the judge does that tomorrow, what you would have done is to give no effect to this particular letter you wrote.
The challenge, and I'm going to come to you, Hamza, but the challenge with this argument that you're now positing is that, and you talk about morality.
Yes, the law has a moral character, yes.
But I also heard the argument you made in the past when Gyakye Quayson, popularly of Asin North, when there was a decision on him by the courts and his lawyers decided to file a stay of execution. And the argument that you made at the time, when I say you, not as in you, as in person, because I didn't hear your opinion on that matter. I mean, I know you're one of those people who can express your opinion regardless of whose ox is God, not as in you, but I mean the party you belong to expressed a certain legal opinion, a legal stance at the time. At the time, the stance was that, look, the fact that there is a process in court, which is to say stay the execution, in itself does not operate as a stay, as in Janyamoye, until the court hears the matter. So the consistency with the principles is what will come into question now. Do you think anybody who makes that argument today is a valid argument he's making?
You see, to put it in context, Moro,
okay,
there are two applications.
Right.
I don't remember, or maybe I could recollect faintly, but there were not two applications. Here, there's one at the Supreme Court,
okay,
to quash the very judgment you seek to put into operation with this letter.
Right.
And that has been fixed for 16th December. To quash it. This whole letter is premised on the judgment of the court. But there's an application pending before the Supreme Court to quash that and nullify that judgment.
What? Okay.
Let me just finish this point. If, of course, court is a probability, it could go this way. My point is this. You remember what I said is that we all have a duty to insulate some institutions of state from certain remarks from the public and public contempt. Assuming, we all assume sometimes, these two applications, first, the stay is upheld by the courts, and secondly, the certiorari application is also granted by the Supreme Court. What you would have exposed Parliament to is ridicule and contempt.
Okay. You made your point.
That is my worry.
Okay, that's fine. I guess that you have made your point and you've made it very clearly.